Good day, students, and welcome to another narrated presentation in the theme or the chapter on servitudes, particularly personal servitudes. In this presentation, we will focus on the obligation of all holders of personal servitudes to return the object of the servitude, salva substantia, or, in other words, to return the object substantially intact. It is very important to remember that this obligation applies to all holders of personal servitudes. The usufructuary will obviously have a larger or a more substantial obligation as the usury or the habitator. And I will, in this presentation, articulate the full scope of the obligation as it would apply to the usufructuary, and I will leave it up to you to make the necessary adjustments for the usury and the habitator. Okay, so let's have a look at the first obligation. And this is the obligation for the usufructuary to draw up an inventory of the property if the owner insists on it. Now, this inventory may be executed at the commencement of the usufruct or at a later stage. However, you have to ask yourself, if you are the attorney acting on behalf of the owner to draw up this usufructuary, when would you ideally like this inventory to be drawn up to protect the interests of the owner? Similarly, if you are the attorney or legal practitioner acting on behalf of the usufructuary that will stand to benefit from this usufruct, when would you ideally like this inventory to be drawn up? The reason why I'm asking this is this implicitly tests a number of the applied competencies in the National Qualification Framework, the CHE's applied competencies of ethics and integrity, as well as your agency, your accountability, and your community service. Now, the purpose of framing an inventory is to inform the owner of the nature, the scope, and the state of things which she must receive salva substantia from the usufructuary upon the termination of the servitude. So it is very good to draw up this inventory to provide a list, and that can include photos and detailed descriptions of the status of these things, so that when this servitude terminates, the owner or his or her legal representative can go back to those records and have a comparison to see what is the nature, what is the scope, and what is the state of the thing. There are no exceptions to this general duty of the usufructuary to draw up an inventory, and she can thus be compelled by a court order to comply with the request of an owner. The court could order that the object of the usufruct be returned to the owner if the usufructuary fails to comply with this order to draw up an inventory. Right, so let's look at the second obligation. And this is the obligation of the usufructuary to provide security for the civilitaire exercise of the property and to ensure its return salva substantia upon the termination of the servitude. So you are leveraging your sort of exposure by saying, listen, I'm granting you this lifelong benefit or this time-bound benefit, but in return I want some security just to make sure that you will not completely ruin the property over which I've created a benefit for you. Now, the owner may demand that the usufructuary provide this security when the servitude is created or at the commencement. So here it is similar to the inventory in that both can be drawn up at the commencement. However, what differs is that the security can be demanded as well throughout any period of the duration or operation of the personal servitude. Typically, this will not be provided at the end, but it can be provided anytime throughout the operation of the servitude. Now, the right of the usufructuary to draw both the civil and the natural fruits of the property may be suspended if the owner insists on the provision of the security and the usufructuary is slow to acquiesce to this demand. A court may order that the object of the usufruct be returned to the owner if the usufructuary fails to comply with this latter order. Now, before we proceed, it's very important to appreciate that there are 5 common law exceptions to this obligation to provide security. The first one is that if a father is the usufructuary and his children are the owners, he is automatically accepted from providing security. The inverse is true for the mother. If the mother is the usufructuary and the children are the owner, she can be accepted, but this is not an automatic right for her to be accepted. This must be explicitly included in the creation of the usufruct. Now, there are at least one author that I can think of immediately that has written about the discriminatory nature of this obligation, or this exception rather. The third exception is that if the owner herself reserves a usufruct in her favor, then there will be an exception for her when she sells or donates the property. A fourth exception is where this usufruct is created inter vivos, and it is explicitly stipulated that the usufruct will be accepted or relieved of this obligation. So it's very important for you to pause and look back to your law of succession module. You should know what an inter vivos creation of a usufruct is, as opposed to or distinguished from a usufruct that is created mortis causa. And then the fifth exception is there will be no obligation to provide security if the state is the usufructuary. All right. Now, it appears that the courts have some discretion in the enforcement of this obligation if the usufructuary is genuinely without the means to provide security that is demanded by the owner. It is here that Professor C.G. van der Merwe notes that it is in principle possible for the court to order that the object of the usufruct be leased, and that the civil fruit, so that the lease, the rental income that is so generated, must be provided as security. Now, the amount of the security that must be provided by the usufructuary is usually determined with reference to the value of the object. And that's why it is important to draw up a list or an inventory of all of the property that falls under the usufruct, because that will help to determine the value of it. And this is usually determined at the beginning or the commencement of the personal servitude. The security that must be provided for movable things may be by way of a surety or a pledge, and for immovable things it can be a mortgage. And for all of these types of security, you must refer back to your chapter or the theme on real security. There is also the possibility that other kinds of real security can be provided in future. Okay, so the third obligation of the usufructuary is to conduct all the maintenance work that a reasonable person or the bonus pater familias would have undertaken at her own cost. Very important. So this typically includes the costs to produce and harvest natural fruit and to gather civil fruits. The usufructuary is bound also to pay all the normal and regular expenses and charges in respect of the property. Since the usufructuary is under no obligation to improve the property, the owner must pay for all the extraordinary costs to ensure the continued existence of the property. However, the usufructuary will have the right to remove any improvements through the jus tolliendi that she made to ensure the continued existence of the property, or to claim for compensation in terms of the principles of the law of unjustified enrichment. So here I want you to pause and link forward to the theme or the chapter on remedies to protect ownership, but also to link forward to the final year of your studies where there is an elective in the Department of Private Law. I apologize, it's a compulsory module in the Department of Private Law that focuses on the law of unjustified enrichment, and there you will focus in much more detail on the law of unjustified enrichment and the principles that underpin it, for which you can use to claim compensation. This then brings us to the final obligation of the usufructuary, which is that the usufructuary may not destroy, damage, or change the nature or substance of the object. Now, in Geldenhuys versus Commissioner of Inland Revenue, the court held that a usufructuary had a duty to maintain, firstly, the size, secondly, the quality, and thirdly, the integrity of the object by not consuming it entirely through normal use and exploitation. The usufructuary may further not change the use or economic destination of the object to increase the income from it or its value. Now, this part of the obligation is usually interpreted very strictly as an absolute prohibition on the deterioration or the impairment of the object. However, in Fourie versus Minnick, the court cautioned against an overly strict and narrow interpretation of the Salva substantia requirement. The court reasoned as follows. For while, on the one hand, there must be no destruction or substantial impairing or undue deterioration of the usufructuary property, one should, conversely, not insist on such counsels of perfection regarding the use as to make the enjoyment something unsubstantial, unproductive, or illusory. So therefore, a flexible and a pragmatic approach to the Salva substantia obligation would allow some interference with the object as long as the economic destination of the object is not altered. Here, a court could consider a number of considerations to enable such a flexible or a pragmatic approach. This includes the locality of the object. So just simply stated, where in South Africa is it? Is it in the Gauteng province? Where in the Gauteng province? In which municipality, for example? What established practices exist in that area? What is the nature of the object? So very important, link back to the chapter where we discussed the nature of objects when it's classified either by its negotiability or its economic function. And we could also then look at, a court could also look at the circumstances that are relevant to the use and enjoyment of the object as contextual factors to determine the desirability of an interference with the object. There is a second possible sort of amendment or dimension to this flexible and pragmatic approach, and this includes that the strict requirements of the Salva substantia obligation could be replaced with another obligation, which is the Salva aestimatone obligation, which is where the object would be returned without any impairment of its value. And then a last feature of this approach might be to accept that economic gain, so enhanced value of the object, is a valid reason to justify a change in the use or economic destination of the object.